Support comes from Missouri Forest Products Association, committed to sustainable and sound conservation of the state's forests, which support more than 41,000 Missouri jobs, resulting in a $10 billion industry. ChooseWood.com.
From St. Louis Public Radio. This is St. Louis on the Air.
And I need to jump in here with some breaking news. We have just heard from our correspondent who is there in Boone County, Missouri today, and she reports the hearing has just ended. The judge denied Attorney General Eric Schmidt's motion to lump all the schools together. This is not going to be a reverse class action. The judge also denied Schmidt's request for a preliminary injunction to stop the mandate as a class. And so these mask mandates can go forward in school districts across the state of Missouri. And it seems to me, as an outsider to the legal system looking in, that the local government suing the Rams had a very good month. Sarah, how good a month was this?
It was a good month. The city has the NFL by the throat.
The Zoom call allows for the process to be expedited, allows the judges to handle more cases and get them off the docket.
Instead of spending 4 non-billable hours driving to Kansas City and 4 non-billable, did I say non-billable? To come back.
I'm Sarah Fensky. Litigation over the Rams' unceremonious departure is now cleared for trial. Could that mean a $1 billion windfall for St. Louis? That's the price tag some people have put on local government entities' lawsuit against Stan Kroenke and the National Football League. But are we wrong to count our settlement money before the case is even settled? That's a good question for a legal expert, and fortunately, we have 3 of them joining us today. Yes, today is our Legal Roundtable, and we'll dig into not only the litigation over the Rams' departure, but also mask mandates and the constitutionality of Zoom testimony, and much, much more. And to that end, we have 3 ace panelists with us today in studio. That includes Mark Smith. He's a longtime attorney and the former associate vice chancellor and dean for career services at Washington University. Mark Smith, thank you for joining us today.
Thanks for having me.
And we're also joined by Eric Banks. He's a former state prosecutor and former city councilor for the city of St. Louis. He's now in private practice at Banks Law. Eric, welcome back.
Good afternoon.
And last but not least, this month we're joined by Sarah Swadish. She's a partner at Sadeh Harper Westoff, who specializes in labor and employment law. So Sarah, welcome back.
Thank you. I'm happy to be here.
So I'm going to get to the Rams in just a moment. But first, there's a high-profile case that had a hearing this very morning. That is Attorney General Eric Schmidt's attempted reverse class action lawsuit against mask mandates in schools. He wants an order declaring all school districts that have mask rules are part of a class of defendants. And he also wants an order that says that they cannot require masks of their students. Now, this case was heard in Boone County at 9 a.m. this morning. This case is still ongoing. We're waiting for the latest from our correspondent who's at the scenes, but I can report that the judge denied the motion to dismiss. Mark Smith, when we talked about this case on last month's Legal Roundtable, a lot of people thought this is just political posturing. Eric Schmidt can't really do this via a reverse class action lawsuit. Are you surprised it survived that motion to dismiss?
Yeah, it does seem pretty unusual. Having said that, a motion to dismiss says you don't really even need to look at the facts. Just on its face, it's different from a motion for summary judgment. So it's tough to get a motion to dismiss upheld. So I don't know that I would read too much into the fact that this wasn't granted, but I don't think it means necessarily that Eric Schmidt's going to win. And you know, there's clearly the political aspects. He's obviously a candidate for Senate, and so this kind of stuff and suing China and some of the other things he's done may not be legally the strongest actions, but they certainly benefit the political side as well.
So, Eric, something else went Eric Schmidt's way this morning, and that is the ACLU had filed a motion to intervene on behalf of 3 kids with disabilities. And they argued there that these students have a right to attend school and have their disabilities accommodated, that COVID-19 would hit them really hard. And so, if people are allowed in without masks, this could really hurt them. The judge also denied that motion. Is there good reason he would want to do that?
Well, as we have discussed before, any lawyer that is not very, very careful about opining in public about what a judge, the efficacy of what a judge did, is at risk of having the Office of Disciplinary Counsel look into the situation. So with as much judiciousness as I can muster, I'll just say that I find the decision perplexing.
Perplexing. Interesting. Sarah, this idea of these kids with disabilities wanting to wear masks, wanting their classmates to wear masks, seems like kind of a sympathetic argument there.
Yeah, I'm surprised that a judge wouldn't let the I think the ACLU wasn't allowed to intervene on behalf of these kids.
No, that's right.
And that is surprising. I'm guessing that, maybe I'm speculating too far, but the judge says this is a circus. Let's keep it simple. It's a motion to dismiss. We take the facts at face value. We're not going to weigh in on whether a fact is accurate or not, but let's keep this simple. Let's not make it a bigger circus than what it already is.
And on the reverse, where people have been challenging the mask mandates on their own, the courts have been very sympathetic to arguments that that this mask mandate does not make an exception for a disability, and it does not make an exception for religious reasons. So like the California case, the restrictions on what you could do in church were less than what you could do in shopping. And they said, well, that you can't do that. You got to treat religion at least as good. And if I have some kind of disability that will prohibit me from wearing a mask, then they need to accommodate that. So I'm kind of surprised. This is a reverse of that, but it still seems like they should be thinking about that, or I'm not sure. I'll be curious to see if there's any kind of written decision on it.
Yeah. We actually have a question that has come in via the phone line. Sandra from Bridgeton is wondering, she notes that if Eric Schmidt is successful with this lawsuit, that it will be endangering her child. Would she have the ability to sue him over the lawsuit that he's filed against these Columbia schools that could also apply to some local schools here in St. Louis County?
Yeah.
Well, anybody with $200 in state court or $400 in federal court can file a lawsuit. And of course, I'm being a little bit snippy because the underlying unspoken question is, what is the probability of success? And there's 2, slim and none.
So you don't think an individual parent would have the ability to push back?
Not against the Attorney General, no. I mean, there's all kinds of immunities that I may disagree with ordinarily, but even I would reluctantly say, yes, official immunity should probably prevail here. We can't have citizens filing lawsuits because they don't like the decisions that the elected official made. The remedy is not filing the lawsuit. The remedy is voting the person out of office. I may disagree with the position he's taken. The mother certainly has my sympathies and my empathy, but she has no chance of being successful.
Well, those are some words that I'm sure that's hard for parents to hear. But Eric, I appreciate you cutting right to the chase on this one. Now, the Columbia School District is defending this, and really whether or not they're successful in defending it could affect up to 50 school districts around the state if Eric Schmidt is successful in advancing this as the reverse class action that, again, a lot of people skeptical about. They've said that this shouldn't apply here. He's basically pointing to that newish state law that has to deal with public health orders. They say these aren't public health orders. These are internal mitigation measures applicable only to schools, part of a larger plan to control the spread of COVID-19. The attorney for the district said the Attorney General's choice to cherry pick the mask requirement from the rest of the district's COVID mitigation measures shows how illogical his claims are on review. If the Attorney General wishes to argue that the district's mask requirement alone is a quote-unquote order, then So must be the requirements that students socially distance, wash their hands, and sit in assigned seats. Mark, I feel like they're making a good point here.
Yeah, I think Schmidt focused on this, at least in his pleadings, because he said, children are at such lower risk. Although that seems that factual assumption seems to be changing because of the Delta variant, which I know is supposed to be dropping off now, but it seems like it's hit children harder. So that's why he said he's going after the schools rather than. Now, why not these other factors as well? Why just pick the mask? The reasoning there may be the political issues that we talked about before.
And I need to jump in here with some breaking news. We have just heard from our correspondent who is there in Boone County, Missouri today, and she reports the hearing has just ended. The judge denied Attorney General Eric Schmidt's motion to lump all the schools together. This is not going to be a reverse class action. The judge also denied Schmidt's request for a preliminary injunction to stop the mandate as a class. And so these mask mandates can go forward in school districts across the state of Missouri. Attorney General Eric Schmidt said now he will file a request for a preliminary injunction against the Columbia mandate, so more focused on the schools individually.
Right, and so nothing. So nobody has to do anything right now. I mean, if he's going to seek a preliminary injunction, they're free to keep doing what they're doing until a judge grants a preliminary injunction. And a preliminary injunction is only the first step. Then you have a hearing on whether you get a real injunction, and you have to have a whole evidentiary hearing. So I think we're a ways away then.
Okay. Our correspondent also reports it's unclear whether he will also try to file preliminary injunction requests against other individual districts across the state. That seems like that would be a ton of work if he wanted to go that route.
And I think the circuit judge made the right decision. I mean, if you look at typical class action factors, you have to have commonality, typicality, numerosity. I mean, if you look at commonality, you're going to say, well, a rural school in Missouri with 80 kids in the entire high school is vastly different than Columbia, Missouri. A rural school, maybe they can. I went to a small high school where the horse was taken out to the football field and fed. We can socially distance at that high school. It's vastly different than Columbia, Missouri, where I would guess a typical class of high school graduating kids is 400 kids, maybe?
Probably more,
maybe 500. I don't know Columbia well enough, but you're not going to have commonality, typicality among how do we mask, how do we social distance, how do we have all of these other COVID measures. And so I think Schmidt needs to go to school by school and say this mask mandate or your protocols aren't appropriate for this particular case. I don't think the class action or reverse class action, as you're calling it, would be appropriate for all schools across the state of Missouri.
So for now, these school mask mandates stand. There's also a lot of fighting over whether St. Louis County has a mask mandate. County Executive Sam Page says he has the right to mandate them. The Judge Ellen Roboto, said he didn't, at least not the way that he did it. So he issued a new mask mandate yesterday. Councilman Tim Fitch called the order illegal under a provision of a new state law that limits public health orders to 30 days within an 180-day period, and he argued that the county could not issue a second mask order until next year. Mark, I have to wonder, though, this previous mask order was found invalid. Right. Doesn't that open the door to say, okay, we get 30 days of a mask order?
I think it does, because the previous one was found invalid because the county council said we don't support it. Now
they've now come around.
Well, but they didn't vote on it.
Right.
I would think they'd have to have, what Page is saying is, well, I've got 2 more votes now. The Democrats have come over, so they'll support me, but there's not been a vote. Now, having said that, you've got Councilman Fitch, who was chief of police in the county, telling people, well, you should go out and violate this. The whole thing's kind of strange, because you also have Page saying, we don't intend to punish people with criminal sanctions or anything, and that was an issue with Roboto's ruling before, because she said, well, you're not really enforcing it. Mm-hmm. So, she kind of said in her ruling, when you read between the lines, this whole thing's very confused and is a big mess. So I think, my sense is Page is just trying to say, we think this is a good idea. We're putting this out there, but we're not going to put people in jail if they don't follow it.
Yeah, I agree. So On July 26th, the county passed the mask mandate.
Right.
Schmidt sued the same day. On the 27th, they rescinded the vote.
Right.
And so this is more procedure over substance. Nobody has said the mask mandate is invalid or unconstitutional. The county rescinded the vote. Schmidt relied on that rescinded vote to get his preliminary injunction, and the judge was like, well, I guess if they rescinded it, then yeah, there is no mandate. And so when Page tried to extend the mandate, the judge essentially said, well, it's been rescinded. There's nothing to extend. We don't have a mandate, so there's nothing to extend, which is really form over substance. Page just needs to bring the council back together to vote on the mandate. And I don't think, the way I read the judge's order, I don't think she would grant a preliminary injunction. She said, post, this is for the health of the citizens. Feel free to post throughout the county that, the masks are encouraged. I think if it gets back in front of her, I don't think she would give Schmidt, because she essentially said, there's nothing to extend. You rescinded it. So I don't think if Schmidt comes back to her, she would give the preliminary injunction prohibiting the mask mandate.
There's also this state law that was just passed saying you can't have it a ban for more than 30 days, I think, and so who knows what's going to happen with that too. And if they're, they've just instituted this thing on yesterday, so who knows what's going to happen a month from now.
We're talking today to our Legal Roundtable. Man, all of the fights over mask mandates across this state of Missouri. Who knew this would be the hottest legal issue of 2021? Our Legal Roundtable today includes Mark Smith, Sarah Swadish, and Eric Banks. We need to take a quick break, but we'll return shortly. And when we come back, we're going to talk about the Rams relocation and a possibly billion-dollar question. This is St. Louis on the Air on St. Louis Public Radio. Welcome back. Today, our Legal Roundtable is in session, and that includes 3 expert attorneys. One of them is Eric Banks. He's the former state prosecutor and a former city councilor for the city of St. Louis. He's now in private practice at Banks Law. We're also joined by Mark Smith, a longtime attorney, the former associate vice chancellor and dean for career services at Washington University, as well as Sarah Swadish, a partner at Sadeh Harper Westoff, who specializes in labor and employment law. Now, I promised we would talk about the Rams, and we are going to talk about the Rams. And it seems to me, as an outsider to the legal system looking in, that the local government suing the Rams had a very good month. Sarah, how good a month was this?
It was a good month. They filed a motion for summary judgment to have the case dismissed, and it was denied by the city. I'm going to go through a little bit of the history as a reminder, because frankly, I had to remind myself. Kroenke became the owner in 2010. In 2014, the Post-Dispatch reported that he bought land in California. In 2015, California approved a new stadium, and same year, St. Louis said, here's a $1.1 billion new stadium for you. Kroenke and the NFL rejected it, and half of it was going to be publicly funded. Kroenke rejected it, and he put in his own $1 billion for his new stadium. So 2017 lawsuit was filed for breach of contract, unjust enrichment, fraud, and tortious interference, and the NFL and Kroenke tried to get the lawsuit dismissed, and McGraw went through each claim and rejected it, and so it looks like we're set for a January 2022 trial in the city.
And so every single one of these claims advances at the trial. Eric, does this look like the city has a pretty strong case? The other government entities suing on behalf of St. Louis, I should clarify.
They certainly do, even though I historically have said that you have about as much chance of deciding what a jury is going to do ahead of time as taking 2 dice and throwing it against the wall and coming up with the correct numbers. However, I would want to be on the city entity side on this one. And in addition to what Sarah so accurately said, if I'm not mistaken, the NFL took the judge's decision up by means of a writ of prohibition, which for lay people, I'll say, is almost like an appeal before the appeal. And the Supreme Court said no. So they have absolutely nowhere else to turn. There's no federal question, so the federal courts are not going to intervene. This case will be settled or it will be tried in January.
And these guys have to turn over their financial records, too.
That's exactly what I think is the interesting by not winning on this motion for summary judgment. And that's where you take a bunch of facts and you give it to the judge and say, Judge, this is not a case. And McGraw's saying, no, there's a case. Doesn't mean you're going to win. The other side's going to win, but there's a case here. So then you get to engage in discovery. And they've asked for all their records because, as Sarah said, there's some claims for torts. And with tort damages, you can get punitive damages. And so typically damages are just trying to make you whole. Mm-hmm. But punitive damages, as they sound like, are there to punish the other side. So if you want to punish the other side, you got to find out how much money they have so you know how big a punishment to give them. So these guys don't want to give up their records.
I mean, this could be very embarrassing, some of these details.
Yeah. And I'm sure they're going to try and protect them and keep them under seal and everything. But you don't want people going through your records, and they've got too much to lose there. Now, going through the counts, this breach of contract, the St. Louis City and the other, we're saying we're third-party beneficiaries. Typically, a breach of contract is you have A and B contract with each other, and they can go against each other. But this is a third party. Much harder to win those kind of cases, and you have to show you're a third-party beneficiary, and there's a difference between an intended versus incidental, and it's very fact-specific. So I think that's going to be a rough one to win. This unjust enrichment.
Oh, I'm going to disagree.
Oh, you think that
one's... Oh, yeah. McGraw...
You think they're an intended beneficiary?
Oh, absolutely. McGraw went through... There's a relocation policy, and the relocation policy says you can't move unless you meet... these guidelines, and the relocation policy refers to home territories, mm-hmm. which is the cities, the stadiums where they're located. And the relocation policy specifically refers to the clubs and the home territories as parties in interest.
Yes. Okay.
So I mean, the contract specifically says they are a party in interest. So I think the breach of I think they can show breach of contract. And as far as punitive, Sarah said, is $1 billion too much? No. The Rams are now the fourth wealthiest team, highest valued team in all the NFL out of 32 teams. And Kroenke paid a $645 million relocation fee. That's more than half a billion.
And they're suing the NFL, too, so it's not just Kroenke.
Yeah,
right?
I don't think $1 billion is out of the realm when you say, okay, the Rams are the fourth most highly valued team, and he paid $645 million to move. Also, I don't think $1 billion is a stretch by any measure.
And while I agree completely with Eric, you never want to try and predict what's going to happen. I don't know if you guys remember when the Blues were going to leave St. Louis and they were going to go to Saskatoon, and for some reason I was at the courthouse and I sat in on the opening arguments about that, and it was St. Louis lawyers, a St. Louis jury, and they were just talking about Saskatoon and what a joke of a city it was. And I mean, I've never been there. I'm sure it's a charming place, but to St. Louis, and the jury was eating it up because, of course, it's not St. Louis. And I think if I had to predict what was going to happen, I would think, the NFL's going to want to not have all their dirty laundry aired, not have everyone's looking through all their stuff. They'll try and offer, an expansion team or something to make everyone happy. But you don't think they'll try and do that?
I don't see an expansion team coming this way. I think all the owners' financials are going to be disclosed. I think we're going to find out just how much money these clubs are making. Mm. I think the city has the NFL by the throat. Absolutely. One of the claims was for fraudulent misrepresentation, and the argument, the city's argument against the NFL was, hey, you induced us to pitch you a new stadium, and it cost $18 million for the consultants and the designers and the engineers. It cost us $18 million to pitch you to stay here, but in 2014 you bought the land. You induced us, and the NFL's counter argument was, yeah, in 2015 you knew we were leaving. You knew we bought land. I mean, they're trying to have it both ways, which was, this is not a breach of contract. We didn't owe you any duty, and you knew we were leaving, and this is all on you, you fools.
So Mark sees the NFL wanting to settle this case, and it certainly sounds like they have some reason to want to settle this thing. Eric, if they offered you $1 billion and you're there representing these St. Louis government entities, would you take that deal or would you go to trial?
In a heartbeat, I would take it. If for no other reason, it's taking, on average, 18 months for appeals to work their way through the system. If that's on average, this would be probably 2 or 3 years, because you know that it's going to take the judge the maximum amount of time, 90 days, to rule on a motion for new trial. And then it will go to the Missouri Supreme Court after the Court of Appeals.
And Eric, I love that you are just assuming that no matter what the jury does here, this is something where there's going to be an appeal. I feel like this is something lawyers know that non-lawyers are often surprised by. Like, this thing could be tied up for a long time, even if the jury comes back with a huge number.
Yes, what my peers say is that a jury verdict is just another step in the settlement negotiations.
Oh, I would not take this deal. If I represent the city, absolutely not.
Sarah's going for broke.
It's $1 million. You're getting a third contingency fee, maybe. What about that?
Well, look, the Cowboys are worth $1 billion. Look, let's not pretend this problem has been going on since 2018. This started in 2010. Kroenke complained that Edward Jones Stadium wasn't in the top 25% of stadiums. He sued us. There was an arbitrator panel. The city lost. He made the city pay $2 million in attorney's fees to him because he didn't think his stadium was up to snuff. Forget you, Kroenke. You came after us for $2 million. We're going to get $1 billion. We're going to get better than $1 billion. It's a city venue. And we have named every single owner. It's not just the NFL. It's not just Kroenke. We've sued the Arizona Cardinals, the Minnesota Vikings, the Giants, the Steelers, because they all knew that California was going to be more lucrative, and they let him take off. He paid a $645 million relocation fee. I'll bet you a donut that money went to the other teams to pay legal costs in case they got sued. $1 billion is nothing to the NFL. It's absolutely nothing. There's going to be an appeal. This thing has been going on since 2011. It's like Game of Thrones. It's only going to get better. You just got to stay with it.
Mark, you got to be the tiebreaker here. I mean, Eric's ready to settle. Sarah's not ready to settle. Well, what if it's $1 billion? Would you settle?
I don't know. I don't know how much money they spend, what they want, and what, we've got these different entities or the plaintiff. What do people really want? Do they want an expansion team if that were available, which it may not be? I don't know.
We want a pound of flesh.
There are a lot of people.
Sarah, I love your attitude toward this case.
I'm putting Sarah on this case. Boy, I think that she'd represent St. Louis well.
Well, look, we're talking about settling cases. I want to speak to a policy shift that might be going on in St. Louis because St. Louis has a new city councilor. This new city councilor is Sheena Hamilton. She's actually an equity partner at the same firm that's been a big part of the successful strategy so far in this Rams litigation. That's the firm Dowd Bennett. Eric Banks, why would she want to leave Dowd Bennett to take a job as the city councilor?
Sense of public service, the ability to make history. Mm-hmm. I mean, there's not that many African-American female equity partners at dominant law firms in St. Louis, but historically there's even fewer city councilors. She will be only the second female city councilor in the history of the city. She will only be the she'll be the fourth African-American city councilor in the history of the city, the first African-American city councilor since 1999.
That's a long drought right there.
So in over 20 years, there have been no African-American city councilors.
And Eric, were you the last one before her?
I was the last one, yes.
Wow.
Judge Ronnie White was the first. After 14 months, he was selected to serve on the Missouri Court of Appeals, followed by the Missouri Supreme Court, followed by a brief stint of private practice before becoming a federal judge. And the late Tyrone Taborn, who we lost last year, unfortunately, was the second city councilor who filled in Judge White's unexpired term. and then it was me. And after that, it was Tom Ray, Patty Hagerman, Mark Garvin served as interim, and we had one more most recently served as interim. Of course, Judge Julian Bush as well.
Mm-hmm. So there's a long history here of a lot of white people serving in this job. This feels like a big deal to have a black woman get this position.
Yes, and I think she may actually be the youngest city councilor ever selected. Not that you're supposed to expose anybody's age, but a little birdie told me she's about 36. Judge White was 39 when he was selected as city councilor. I was 42. I suspect that Tyrone was older than I was. So the fact that somebody under 40 is being able to serve in this esteemed position is quite noteworthy.
So that's exciting. What's also interesting is that this could signal that the city's going to handle some things in a different way. The mayor's chief of staff, Jared Boyd, told our own Bill Freivogel, who's frequently a member of this panel but also works as a journalist at times, he told him that going forward, this means they're going to change how they handle police abuse cases when the city is defending these officers that have done things that maybe aren't so defensible. He said there would be less consideration of the financial loss a case might mean for the city. Here's a quote from Jared Boyd. "The new city councilor is going to be given a mandate to reconsider what winning looks like. It's not to say we shouldn't be cognizant of city resources, but that can't be the only thing." Mark, do you think this sounds like a good change?
I think it probably is. And by the way, Jared's been a guest on this show a number of times, too.
Jared's a smart man.
Yeah, he is. So there are two cases right now, and I think Bill wrote about that are, one was where the police did a no-knock kind of raid, and this man was killed. He was shot like 9 times. And the other one was a case where a prisoner was being restrained. He had handcuffs on, or leg restraints, and then he was prone, and the officers were on top of him. He stopped breathing, and apparently was saying, "Stop, I heard," or something like that. And both those cases are now before the courts. In the past, the city took the position, we don't negotiate, we fight them out. And I think now they may try and that's what Bill's hearing from Jared Boyd is, we may just settle these. And I also think, the courts used to give a lot more leeway to police officers, and I think that's in flux now, too.
Sarah, should taxpayers be concerned that this means, while we all believe in justice, when it hits our own pocketbook, that might hit us differently? Could taxpayers end up paying a big burden for some of the things these officers have done?
Well, sure, for what the officers have done, sure. If there's a civil trial and we're found and the city's found liable, sure. But I think Tashara Jones is taking the right approach. As a plaintiff's attorney, I am surveying, where are the judgments coming from, who is getting sued, and what do the judgments look like? In the state of Missouri, and I assume St. Louis City has been similar, the state of Missouri doesn't want to sue. They have the constant fear of one lawsuit begets the next lawsuit. We don't want to encourage lawsuits, so we're not going to settle. So if you go look at the highest awards in lawsuits, it's always against the state, the Department of Transportation, the Department of Corrections, because they don't want to settle. Their business decision is don't settle. And so valid claims come in that are worth a lot of money, and they won't settle them because the business decision is don't settle. Whereas if you go to, I'm going to pick on some private entities, Anheuser-Busch or Boeing or Walmart, if they have a case with high liability come in, they're for sure going to settle it because it has such high liability. The state doesn't make those business decisions. And I think by bringing in Sheena Hamilton, the city is going to say to itself, we're not going to have a no-settle policy because that's where the big judgments come from. If there's liability, let's settle it. Let's be done with it. And if there's a lawsuit that comes in that they don't think has merit, then they're going to draw the line. Instead of a black or white, we don't settle.
So, Eric, sounds like this might be the fiscally prudent move.
Without a doubt. I have defended corporations for many, many years and drank the Kool-Aid about we'll spend millions for defense but not pay a penny for tribute. Guess what happens? You end up spending millions for defense. And of course, you could have paid the penny for tribute. And in addition to that, you're going to lose some of those cases. So you're making this stand because of, quite frankly, your ego, because it makes no fiscal sense whatsoever. So I believe that this change in policy is going to end up saving the city money and not costing the city money. And quite frankly, the only efficient way to engage in meaningful behavior modification is through somebody's pocketbook or wallet or purse or whatever euphemism you want to use. So if we end up in the short run paying some big verdicts because of some illegal, reprehensible behavior, that's a very, very small price to pay for people to have a better opinion of the law enforcement officers, 99% of whom do a very good job. And it is the 1% that is affecting the public's attitude for the overwhelming honorable men and women who serve in this great profession. And as a result, it's difficult to win police credibility cases in the city of St. Louis because for too long, this small renegade bunch have been able to operate with impunity because of the thin blue line, because of this idea of, well, we can't pay anybody any money for getting their head beaten in. That's just life on the street. And there's a new sheriff in town. There's a number of new sheriffs in town. And the way things have operated in the past will not be allowed to continue to operate. And the quicker we figure that out, the better off we're going to all be.
We're talking today to our Legal Roundtable. That is attorney Eric Banks. We're also joined by Sarah Swadesh and Mark Smith. We need to take a quick break. Coming up next, the right to confront your accuser in the age of Zoom. This is St. Louis on the Air on St. Louis Public Radio. Welcome back. We are talking today to our Legal Roundtable. Today that includes Sarah Swadesh, who's a partner at Sadeh Harper Westhoff. She specializes in labor and employment law. We're also joined by Eric Banks. He's a former state prosecutor and former city councilor for the city of St. Louis. He's now in private practice at Banks Law. We're also joined by Mark Smith, a longtime attorney and the former associate vice chancellor at Washington University. Now, we all know that in this era that we seem to be stuck in permanently, that a lot of business has moved to Zoom, and it's certainly safer and more convenient in the age of COVID. But are there legal implications when criminal matters move to Zoom and then civil trials move to Zoom? Earlier this month, the Missouri Supreme Court heard the case of a St. Louis man who'd been convicted of statutory rape in a case involving his girlfriend's teenage daughter. Rodney Smith says he didn't get a fair trial because a technician who handled key evidence was allowed to testify via Zoom. Now the Missouri Supreme Court is hearing this case. Sarah, is there cause for concern here about this type of testimony?
When I initially read the case, I thought, oh, BS. This is just a technician who took the swab out of your mouth. There's no smoking gun. You don't have some sort of scorching cross-examination of this technician. The technician couldn't be there. He was on paternity leave, so he couldn't testify. And I thought, oh, BS. You know what? You're looking for a way out to get out of prison. And I had to reassess my position because in my mind, he's a pedophile. He is a sexual predator, and nobody has any sympathy for those folks. And so I was like, no, you're done. And as a plaintiff's attorney, I agreed to do an arbitration this summer by Zoom. I was going to take every witness by Zoom, everybody in different rooms, different buildings. The pandemic has made me very comfortable with Zoom depositions and trials, and so I thought, nah, this criminal defendant, he's just looking for a way out. But I had to stop and reassess and say, yes, it's just one technician by Zoom or two-way TV, but I thought, I had to reassess because I looked at it from the position of, what if I were an African-American man who'd been pulled over by a white cop and there wasn't body camera and I was being charged with, I don't know, DUI or resisting arrest or something of that nature, and I was defending myself. I would want that cop live. And so I thought, I don't care. My personal feeling was I don't care about the sexual predator not being able to take a live cross-examination of a technician because that just seems so boring. But once you allow it for one boring technician, you're going to allow it for and I know all cops aren't racist, so forgive me, and I hope I don't get heat. But if I am an African-American person, I want my white cop live, right? And so it becomes if you allow it for one witness, it will balloon to all witnesses. And I thought it has to be in person, and it is traditional, and it seems old school, but I think that's the way it needs to be.
It's also a requirement of the Constitution. I mean, it's the Sixth Amendment that says you have a right to see, what's the term, to be confronted with the witnesses against you. And so now you might say, well, you could do that Zoom. I had the same reaction to you. At first I thought this is a no-brainer, but then when you start seeing it, and there's two big Supreme Court cases, one where they made an exception for a child because they said the child might be traumatized. And Scalia dissented in that one. And Scalia says, that this is kind of a constitutional right, and it's more than just, is this person available and can you get reliable testimony? And when you listen to the oral arguments that were before the Supreme Court, they talk about, why do we have these trials in these big courtrooms? And I mean, we don't just do it in a conference room or an office. There's a whole thing about it, and it's to make people realize this is important. It's a big deal, and just zooming in would cut into that. Not to mention, if you're doing a Zoom, maybe somebody's coaching you from behind, or you can't see the person's whole body language. So I think, and they probably could have handled this better. It's a little unclear about why this happened the way it did.
In the specifics of this case.
Why they didn't raise it earlier and all that. I don't really completely understand that. But I think as a matter of law, you probably do need to have this kind of person in the courtroom.
Eric, does it feel different to have a witness in the courtroom versus getting to question them over Zoom?
Yes, it does.
It does?
Yes, and ordinarily I am such a analog person in a digital age that it is hard for me to embrace technology as much as we've had to embrace it for the last year. But I think the acceptable compromise, given my cases that have been on the trial docket once the courts have opened back up, it has to be all the parties have to consent to do it by Zoom. And therefore, any one party has the veto ability to continue the case effectively for months, because that's what happens when you are waiting your turn in line for a live court appearance as opposed to doing it by Zoom. But I think that the idea of, look, if all the parties can agree for whatever reason, then we can do it by Zoom. But even if only one party says no, then discretion is the better part of valor, and that should be a live hearing.
And is it your sense that court precedent would go for that as long as everybody consents, that Zoom probably is constitutional?
Oh, I think if they consent, it's fine.
Okay.
Yeah.
I want to go to the phone lines. We actually have a caller who has a question about this. Ron is calling from St. Louis. Ron, hi, you're on St. Louis on the air.
Yes. I think in the future, all small claims and evictions should be allowed by Zoom unless one of the parties object. And if one of the parties object, then if they lose, they should reimburse the other party. For travel expenses, the Zoom call allows for the process to be expedited, allows the judges to handle more cases and get them off the docket. And many times you show up for a case like in evictions, and if the person doesn't show up and then they reschedule it, a Zoom call would be so much more efficient for small claims and evictions.
Ron, thank you for sharing that point. Eric, how would you feel if we moved the real small stuff to Zoom?
And it doesn't have to be just the real small stuff either. I'm on the Missouri Bar's committee exploring these types of issues, and there's a lot of very, very positive equal access components to this issue, because a lot of people can make arrangements to maybe be off work for a half an hour or an hour to participate in a routine hearing by means of their smartphone, as opposed to having to take off at least half a day to drive to the courthouse, find a parking space, go through the metal detector, wait in the bullpen with the 200 other people who have matters pending. And that can be so easily addressed with technology, by phone, by tablet, by computer. I even think that some of the courthouses have set up computers for public folks in the lobby. So even if you don't have your own technology, that you can go to the courthouse and use theirs. Of course, that kind of defeats the whole purpose of how efficient it is if you have to do that. But who's to say that you can't go to, and I realize the digital divide is alive and well.
And I was going to say, yeah, some of the advocates we've talked to in some of these eviction cases, they say you can't expect somebody getting evicted to join by Zoom. You know, they just don't have a good setup. That's something that you got to do in person. But a small claims matter might be a completely different.
Or the routine status matters, the case management conferences, the things that many times lay people don't know anything about because mercifully they're not required to be there. It's the attorneys. And there's just, I still have about 40% of my practice in Kansas City, and it has been marvelous to be able to do a hearing, routine court appearance, and stay in St. Louis instead of spending 4 non-billable hours driving to Kansas City and 4 non-billable, did I say non-billable? To come back, because Kansas City clients are not going to pay the travel time of a St. Louis attorney. So I can have the best of both worlds if I can stay in St. Louis and get the same thing accomplished with technology.
Boy, you're making a great argument for this whole Zoom thing. So it sounds like the key is everybody's got to consent.
Right.
Didn't do that, maybe, in this case. Well, look, we have just a few minutes left here today. We have to talk about the McCloskeys. I went like 1 month without talking about them. They continue to just find their way up onto my docket. Missouri's Chief Disciplinary Counsel wants the Missouri Supreme Court to suspend their law licenses. They have now pled guilty to misdemeanors. They received a pardon, but they did still plead guilty. Alan Pratzel, who holds that job for the state of Missouri, said their crimes showed, quote, indifference to public safety and involved moral turpitude. He recommended that the Supreme Court indefinitely suspend the McCloskey's licenses with no leave to reapply for reinstatement for 6 months. Mark, should they have seen this coming, pleading guilty to misdemeanors?
Well, I think when I saw Pratzel's statement, I think part of the issue for him was they said, yeah, we did it, and we'd do it again, and we'd violate. I mean, so I think that is probably the thing that Pratzel may be
some of their extrajudicial statements may come back to bite them.
The idea that as lawyers, as members of the bar, we're supposed to follow the law and respect the law, and to say, yeah, I'm not going to follow the law in this kind of situation. It's a 6-month suspension, then you can reapply. And he says, you know, there have been other cases where we've done this with lawyers where there's this moral turpitude. So I didn't look to see what the other situations were, but one can imagine.
But so 6 months, this is a small law firm. I checked their website. They do not have any other attorneys at this law firm. Eric, could this be a huge problem if they lose their law licenses for 6 months?
Not really. They probably have more money than God to begin with. So they may welcome the publicity that's going to come from this. It's certainly not going to help it's not going to hurt his bid for becoming a senator. I mean, he's going to, outstate Missouri is going to eat this up. And, you know, once again, it's those, the establishment trying to pick on the person standing up for truth and justice. So I don't feel sorry for them. They're going to be all right.
Sarah, do you think 6 months seems fair in this case in light of these statements about how they do it again?
Absolutely. Absolutely. I think if they had pled guilty, received the pardon, and they showed some sort of humility, maybe it wasn't the right decision, we're not sure, some humility, I don't think they would have their license suspended. But I think they pled guilty, got their pardon, immediately walked outside the courthouse, pumped their fist, and said, we do it again. No lesson has been learned. And you're not following the rule of law. Mark nailed it.
Is there any chance that they could be in jeopardy of not getting that license back after the 6 months are up?
He'll spend 6 months on the campaign trail and he'll get a license back. I mean, lawyers have gotten their license back for lesser offenses, or for greater offenses, rather.
So we just have about 1.5 minutes left here today. But Mark, I know there's some news you wanted to just briefly discuss.
A lawyer, and I think many people in the community knew Eli Karsh, and he passed away, 53 years old, heart attack. Just a great guy. And, he came out of law school. I was dean of students when he was a student. I knew him. And he went, he bypassed kind of big money jobs to do civil rights work and did that his whole life. And if I can tell one quick story, when he was a student, he got called on the first day of class, is what I heard from the students. And it was a contracts case, and you read this case, and it was an old English case. And apparently, most kids, when they get called on, you're just terrified, and he did the whole case with an English accent that was apparently so good that the other students thought he was like an exchange student or something. And it was just, he was really smart and really good guy, and it's a real loss for the legal community and for St. Louis, lifelong St. Louis, and just a terrible, and leaves small children, and his wife Christine's a wonderful woman. It was horrible to see that in the obituary. So.
Boy, it seems like such sad news. It sounds like he was not just a good lawyer, but a funny person.
A good guy and fun and interesting and smart and kind of what you want a lawyer to be,
Well, we wish the best to his family and condolences to everyone who knew Eli Karsh. Mark Smith, on that sad note, I want to thank you so much for joining us today.
Thank you.
And also Eric Banks, who's in practice at Banks Law. Thank you.
Thank you for having me.
And Sarah Swadish, a partner at Sadeh Harper Westhoff. Thank you.
Thank you.
This episode was produced by Sarah Fensky and Alex Hoyer, with podcast design by Aaron Dorr. Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here. If you learned something new from today's episode, consider leaving us a review and rating on Apple Podcasts on the App Store. It's the easiest way to help people discover our show. We appreciate it. Thank you. St. Louis Public Radio is a member-supported service of the University of Missouri, St. Louis.
Support comes from the Missouri Forest Products Association, committed to conservation and careful management of the state's forests to make them more resilient and better habitats for wildlife. ChooseWood.com. Support comes from the Missouri Forest Products Association, committed to conservation and careful management of the state's forests to make them more resilient and better habitats for wildlife. ChooseWood.com.